Yeah, I'm Robert Plotkin. I am a patent attorney specializing in software patents at the boutique patent law firm of Blue Shift IP. We are a small firm in Cambridge, Massachusetts, in the US, specializing in obtaining, enforcing, licensing, selling, and defending against software patents. We have a particular specialty in AI, and we enjoy helping companies of all sizes. Start with what a patent is in general. A patent is a set of legal rights that gives its owner the ability to stop other people and companies from selling a product that's covered by the patent. So if someone invents a new kind of smartphone, it could be an electrical device, computer device, it could be a consumer device, like a tool, it could be software. If the person invents that and it's new enough to satisfy the legal requirements, they can obtain a patent. And that means that no one else is allowed to make, use, or sell the patented invention without the patent owner's permission. That's what a patent is. Now, a software patent is a patent that covers software. So there's patents, like I said, on consumer devices. I have a coffee mug here that I'm drinking from. You can get a patent on new types of coffee mugs, mouse traps, car engines, plants, drugs, chemicals, all kinds of things. And in some sense, a software patent is the same as all of those because it gives that same right to stop others from competing. It's different in the sense that most software patents cover processes. So you can imagine that that's quite different from patents that cover products. Most new types of software have like a new algorithm in there, a process that does something new, maybe performs a calculation more efficiently or effectively than before. And so writing software patents, obtaining software patents requires a close familiarity with computer science, with software development, with computer technology, and with how software works. And then the law in the US and in other countries has developed a lot of specific rules that apply to software patents. So anyone who works on a software patent has to be very familiar with those legal rules. The rules that apply to patents on drugs, for example, are quite different in many ways than the rules, I'm sorry, that apply to software. Even though the statute, for example, in the US is the same for software and for drugs, the courts and the patent office over the years have developed quite different rules for those two different types of technology. That's why we specialize in software patents at my firm. We have specific backgrounds in computer technology, and we've been handling software patents specifically for many years, so that we can handle them effectively, deal with the types of rejections you get at the patent office for software patents, overcome those rejections, and be effective and efficient at obtaining software patents. Is two different things. One is that if you don't understand the technology and the legal rules and you write your patents too narrowly, it can be easy for someone else to effectively copy you, but not infringe your patent. Let me give an example from the copyright world, which is you write an application using a programming language like C or Python or Java, something like that. If someone else sees your software and they write the same, they create another piece of software that does the same thing as yours, but using different code, generally, they wouldn't be infringing your copyright because the copyright only protects the specific code that you've written. So they could really effectively copy your product without infringing your copyright. If you write a patent too narrowly, it can have the same problem, which is that it only covers the very specific way you've designed your software and not other slightly different ways that other people might come up with. So one of the things we always work on doing when we are writing software patent applications is to write them as broadly as we possibly can to make it as hard as possible for the competitors of our clients to copy what our clients are doing and avoid infringing. That's one issue. The other is with AI, there's so many different things you can patent. Imagine that you've come up with a new way of training a model like a neural network. You could patent the method of training. You could patent the resulting neural network. You could patent applying that neural network to some new data like images to recognize images. You can patent many different aspects of the AI invention, or think of it another way. You can patent the same thing from many different angles or perspectives. And if you don't think that through and you only patent it from one narrow angle, you might make it easy for someone else to sell things that do the same thing from other perspectives and not infringe your patent. So I think that's probably what the AI founders you're talking to are saying. I don't know if they're, maybe using law firms that don't specialize in this, but maybe they've had the experience of trying to seek patent protection and it ends up not being broad enough to protect their innovations. Mentioned some of them, and we've published a blog. We have a webinar recently on these. I think I'll remember all 7 of them. There's the method of training. There's the resulting trained model. There is executing the model. There is refining the. There's the output of the model itself. There's doing updated or refined training. There's the refined model. How many is that? Is that 6 or 7?
That's fine.
These are all things that are really common, right? Very often, the output of a training process, like I said, is a trained model, which is really useful for lots of different purposes. These days, people are even using AI to write software. A lot of that going on now, particularly as a result of ChatGPT and other code-based models available from OpenAI and elsewhere, where you can streamline or largely automate the writing of code. Then the code that you come up with can define an application which might be patentable independently of how it was generated in the first place. So that's why I say you really need to, once you've created something using AI, to think through all of these different potential ways to patent it. Ask yourself, what would be the most, is our invention actually patentable in all of these different ways? And of all the ways in which it is patentable, which would be the most valuable for us to patent? What would be the ways in which you really don't want your competitors to be able to copy from you? And those are the ways that you would focus on patenting. So yeah, we do focus on patents. I think the issues relating to copyright are a bit different from what we tend to focus on. But for those people who aren't familiar, the general controversy that there's been so far is that AI models, for example, GPT and the various versions of GPT, are trained on public data, including lots of copyrighted information on the web pages, articles, blog postings, etc. And that all goes into training the model, which enables it to get better and generate output. So there are copyright owners who are upset about this and either don't want their data to be used to train models or want to have some control over how their copyrighted information is used or to get some compensation for that. And I think all of those are very reasonable concerns on the part of copyright owners. I know that OpenAI, for example, is in discussions with companies like Reddit, which was a major source of training data for GPT, to address Reddit's concerns. I suspect we're going to see a bunch of licensing deals struck between companies like OpenAI and major content sources like Reddit or Wikipedia, et cetera, so that we can get rid of the potential copyright infringement concerns, and so that copyright content creators and content owners can be compensated for their works. I mean, the pace of innovation is so fast right now. I mean, almost every day we are seeing significant new developments in AI. I think ever since ChatGPT was introduced, both between people making use of ChatGPT to create other applications or applications within ChatGPT, and the launch of ChatGPT spurring other companies to try to catch up. There's just an incredible pace of innovation. So to even attempt to extrapolate out 5 years is so difficult. It's hard to extrapolate out even a few months. But what I'll say is that a few of the really exciting developments that are going on right now are the creation of the ability to connect to tools like ChatGPT through plugins. I saw a great interview with Stephen Wolfram recently about the ChatGPT plugin for Wolfram Alpha that's enabling you to do natural language queries for mathematical functions, which will then get sent to Wolfram Alpha to perform the computations and then send the results back to ChatGPT to give you natural language output. We know that OpenAI has created a plugin API. There are plugins being released, not all really fully available to the public. But as we see more integrations between generic tools like ChatGPT and other sort of application-specific and domain-specific products, I think the power and usefulness of these AI tools is just going to explode in ways that we can't even predict right now. Another development that's going on is that I think I and many people, when they saw ChatGPT, said, how can we use this and apply it to the current internet, right? Because ChatGPT is only trained up to September 2021. How can we apply it to the current internet? And how can we apply it to our own data? Whether you're an individual or a company, you have a ton of data, documents you've written, your own web pages, databases. Wouldn't it be amazing to be able to query all those sources of data in natural language and get natural language answers out? Wouldn't it be great to say, write an essay or a letter in my own personal style and then have a language model do that? Well, this is already well in the works. We know that Microsoft has announced its Copilot, which is already being tested with a small number of corporate customers. I'm not sure that they've announced a completely public release date, but it will become part of Microsoft Office 365 for their general customers, I'd suspect within the next year. And part of what that's going to enable you to do is exactly what I said. Ask it to write a letter of a certain kind that's similar to letters you have written in the last year, or to a customer based on their own information. I mean, this is just going to explode the range of uses and make it much more tailored to us as users and as organizations. So that's just a couple of things that we know about. Beyond that, it's very hard to extrapolate. To our website at blueshiftip.com. You'll see a few of the key links. We have a ton of publicly available free content. We have podcasts of our own, which focus on software patents. We have webinars, we have blogs. Most of those are focused on tech companies and how they can better protect their own innovations using patents and other forms of intellectual property. You can also check us out on LinkedIn, where we post a lot of other content.